urging the Supreme Court to do what they did. So the majority leader has decided to bring up a bill called the Bump Act. Claims this bill will ban bump stock. The Bump Act targets common firearm accessories, not just bump stock.
See hope and optimism. People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year. Or a case to be brought to go in front of one of those judges and to have an outcome similar to what we've seen in the past. Far-reaching gun law in the history of the world, it is not. But they actually did it.
The Supreme Court recently declined to review a case challenging ammunition limits, which included provisions for background checks on ammunition purchases. Denying emergency review. The recent news from the Supreme Court is highly pertinent to many people. This is especially true in states like New York and California, where there are stringent regulations on ammunition purchases, including those that don't require background checks. In an order included in today's list, the Supreme Court denied emergency review in a case called Gazzola versus Hoco. This case, which has been previously discussed, is a direct outcome of New York passing the Concealed Carry Improvement Act, or CCIA. The case mainly concerns the constraints that arms sellers and federal firearms licensees face due to the CCIA. The law requires a background check for every purchase of ammunition. The plaintiffs argue this infringes on Second Amendment rights. The Gazzola case focuses on how the CCIA law impacts dealers and its broader effects on the right to keep and bear arms. New York's law aims to regulate not only access to permits and the ability to conceal carry, but also to target armed dealers, making it harder for individuals to access arms and ammunition. The plaintiffs in the Gazzola case sought the Supreme Court's intervention to strike down the background check requirement for ammunition on an emergency case. However, the Supreme Court denied their request for emergency review.
I mean, it's really a sad time for a court to make that kind of ruling. They're dead wrong, and they're dead wrong for America. I mean, I don't know what the Supreme Court's going to do. Are they now going to be the ATF? Because the country can't work that way.
This denial followed the lower court's rejection of the preliminary injunctions and the Second Circuit's delay in addressing the matter. The plaintiffs had previously sought emergency review from the Supreme Court, which was also denied, allowing the Second Circuit to issue its decision. The Second Circuit's assessment concluded that the rulings in the landmark Bruen case do not apply to the CCIA. In differentiating Bruen from previous lawsuits, such as Antoniuk versus Gazul, the Second Circuit considered various factors to support its decision. This development highlights the ongoing legal battles surrounding arms control laws and ammunition sales regulation. The Supreme Court's denial of emergency review in the Gazzola case indicates that these legal challenges will continue to evolve, with significant implications for armed dealers, arm owners, and Second Amendment rights advocates.
This is a semi-automatic handgun. As quick as I depress the trigger of this Glock 19, a round comes out of the chamber. That weapon and this weapon are exactly identical. There is no difference. Glock 19 comes with a 15-round magazine, which under this bill is legal. Functions exactly the same. As fast as you depress the trigger is as fast as a round comes out. P320, which some of you probably saw in one of the hearings on the magazine bans, I showed mine.
Impact of the Second Circuit's decision. The Second Circuit Court's stance on the Bruen case has generated considerable discussion, particularly regarding its impact on New York's Concealed Carry Improvement Act, or CCIA. The court argued that Bruen was an exceptional case dealing with a unique restriction imposed by New York. However, the new CCIA law, passed just 8 days after the Bruen decision, introduced even more restrictive concealed carry regulations, including ammunition restrictions. The Second Circuit Court of Appeals argued that Bruen did not apply to this particular issue, despite the CCIA being more stringent in a direct response to the Bruen decision. The court concluded that unlike Bruen, the CCIA in related cases such as Gazzola and Antoniuk were not special. Consequently, the Second Circuit Court of Appeals overturned several injunctions and decisions issued by lower courts that had rejected the CCIA's initial arguments. As a result, New York won several lawsuits. Following these verdicts, several cases including Gazzola petitioned the Supreme Court for an immediate stay of proceedings. The plaintiffs requested that the Supreme Court take early action and reverse the Second Circuit's decision.
For the Senate to consider my legislation, the Banning Unlawful Machine Gun Parts, or BUMP, Act. More than 20,000 people gathered for a large outdoor music festival. No one could have anticipated the nightmare that was about to unfold then. Then over the music, they started to hear what at first people thought were fireworks. Complete panic erupted. Rapid gunfire rained down on the crowd with shots so close together that they seemed to almost bleed into each other. Concert goers ran in every direction, searching for cover where there was none.
It's important to understand that these instances were requesting interlocutory review, meaning they were seeking a review of preliminary injunctions rather than final decisions or summary judgments. Preliminary injunctions are crucial as they can prevent the enforcement of laws while litigation is ongoing. Although not ultimately binding, these injunctions play a vital role in shaping the course of a case. When deciding on a preliminary injunction, the court assesses the likelihood of success based on the case's merits. This evaluation can set a precedent and provide insight into how the case might develop. Organizations like the Gun Owners of America and the Firearms Policy Coalition often file preliminary injunction petitions to prevent the execution of legislation they believe violates Second Amendment rights. The outcomes of these injunction requests often undermine whether controversial statutes like the CCIA are immediately enforceable. The Supreme Court's denial of emergency review in cases like Gazzola means the Second Circuit's decision stands, at least for now. However, this does not end the legal battles. These cases will continue to be litigated and the final outcomes remain uncertain. The Supreme Court's future involvement will be critical in determining whether laws like the CCIA will ultimately be upheld or struck down.
Well, I've got here the actual original brace that this letter was responsive to.
When did Congress pass a law saying pistol braces qualified? This pistol brace was sold in 2012. A guy walked into a gun store, bought it legally, walked out of the gun store with the pistol brace.
And so you had to implement this rule. This brace is exempt from your rule?
Hope remains for future. If the courts grant a preliminary injunction, it often indicates they might favor either pro-arm or anti-arm arguments in the final merit decision. This sets a precedent for future cases, and the winning party usually reaps the benefits. In the current situation, the parties are requesting the Supreme Court to intervene early and overturn the Second Circuit's decision to reverse the preliminary judgment. However, the Supreme Court has denied review of the ammunition background check case for the second time. Despite this setback, there is still hope. This is mainly due to the Supreme Court's actions in another case involving the Concealed Carry Improvement Act, or CCIA. The Supreme Court has put the Antonio case on hold, likely due to their upcoming decision in Rahimi. Rahimi is a significant Second Amendment case that applies the Bruin analysis to federal restrictions on the possession of firearms and ammunition, specifically concerning individuals subject to domestic crime restraining orders. Although the Antonio case is on hold, the Supreme Court is sending a message that the Rahimi case will affect other matters requiring the Bruin test. They are also indicating that Rahimi will impact the CCIA. Following the Rahimi verdict, it is anticipated that the Supreme Court will either grant, vacate, or remand the Antonio case. Antonio addresses a comprehensive challenge to the CCIA, including its legality, its analysis of Bruin, and how the Second Circuit applied Bruin. The Antonio case is currently on hold, and the Rahimi case is scheduled to be heard soon. Despite the Gazzola case not being reviewed, there is a possibility that changes could occur. Once the Rahimi decision is handed down, it could result in a grant, vacate, or remand situation for Antonio. It is likely that the wording used in Antonio or Rahimi will be referenced in Gazzola. This could lead to the Second Circuit re-evaluating Gazzola, Antonio, and similar cases.
would depend upon the actual design of the individual item. There were numerous different items being manufactured.
ATF estimates that not requiring the $200 stamp from the NFA for a short-barreled rifle. 20 years as a prosecutor, you know the answers to these questions. I'm done asking them. I'm just going to go with
34.
Congress passed a law. They didn't. When did the U.S. House pass a rule classifying a pistol brace as a short-barreled rifle?
The expectation is that Rahimi will provide robust language to address these issues. Gazzola, one of the cases seeking emergency review of the CCIA, went to conference on June 13th. This week, the Supreme Court released the order list which denied review for the Gazzola case. Despite this denial, there remains a glimmer of hope. The Supreme Court's decision not to reconsider ammunition background check systems and their decline to review the Gazzola case means that for now, the ammunition background check systems remain in place. In summary, the Supreme Court's denial of emergency review in Gazzola is a setback for those challenging the CCIA. However, the forthcoming Rahimi decision and the hold on the Antanya case suggest that there could be significant development soon. The interplay between these cases and the potential for a re-evaluation of the Second Circuit's decisions offers some optimism for those opposing the CCIA and its related restrictions. For now, the Supreme Court's choice not to reconsider ammunition background check systems leaves the current regulations in place.
This is what offends the sensibilities of Americans, whether they own these or not. Do these increase the muzzle velocity?
The stabilizing
Do these allow the, you're not answering any of the question.
Rule
Do you think you have the authority to reclassify the firearm above because it can be shouldered?
give classifications, and if things don't qualify under the rule, then they don't qualify.
That's all for this video, folks. See you next time.